Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin in Calgary, Alberta. I'm coming to you from Calgary today to answer any and all employment law questions that you have. Any question you have related to employment law, now's the time to ask them. You have a lawyer with you for the next half hour to answer all your questions. We are on Facebook and on YouTube, so just put your questions in the chat. We'll be happy to get to them as soon as they come in. In the news this last couple of weeks, from an employment law perspective, we've been hearing a lot about Twitter. Twitter originally laid off or terminated half its worldwide workforce, and then last week told the other half that they could either quit or prepare to become very hard workers, where long hours and a high degree of performance output would be expected. So, of course, amongst employment lawyers, this has been all the rage over the last week. Twitter, as everyone knows, is an American company. I won't comment on what American employment law has to say, but I can tell you that from a perspective of here in Canada, if I were an employee being told I could get 3 months of severance or expect to work long hours at a high degree of intensity, I can tell you that the way I would treat that is as a constructive dismissal. So a constructive dismissal is when an employer changes the fundamental term of your employment contract and you don't consent to that. So of course you can imagine that being required to work like long hours at an intense, at a high rate of intensity could easily be viewed as a constructive dismissal. If you were someone that came into work at a normal amount of hours, a normal level of consistency, and now you've got to be, as Mr. Musk was saying, hardcore in your efforts to achieve the goals that he set out for the company, you could require the employer to instead pay you a fair severance. So whether 3 months is fair in terms of severance really depends on each worker. We have 4 main factors that are used in Canada to calculate someone's severance, which are their age, their length of service, the seniority of their position, and the availability of similar work. So we've compressed all 4 of those criteria into a very easy to use severance pay calculator that we have on our website. You can go there yourselves, answer 4 easy questions, and figure out how much you're owed in terms of severance. The website is up on the screen right now. It's pocketemploymentlawyer.ca. That's pocketemploymentlawyer in the singular.ca. This is really just for your information. So we're not, there's no obligation once you've answered the question to contact us. But if you do want to speak with us afterwards, we'd be happy to set up a consultation and let you know what your rights are. Especially if you're coming from Twitter, it's very likely that you're owed a lot more severance. So feel free to reach out, see what we think your severance entitlements are, and whether Mr. Musk's offer really amounts to what you're owed. So we have a question coming in from YouTube, from KD. Can an employer force employees working from home to be always on camera while in meetings? So that's a good question. I mean, we have a lot more adjustments that have happened in the workplace during the pandemic. A lot of people are working from home, and a lot of people are, tuning in via meetings, or employers want to surveil them while they're working to make sure that they're performing correctly. The law is not yet fixed in that area. Generally, if an employer makes a reasonable request of you at work, then you have an obligation to comply. All right. So basically, the question we would have to ask ourselves: is it reasonable for you to be on camera while you're in a meeting? I personally don't see what the issue is, but I might be wrong. There could also, of course, be issues related to, for instance, a disability or other human rights protected ground that might require the employer to accommodate you by letting you stay off of the camera. But otherwise, I think that's a request an employer can make of you, and you would have to, in that case, comply. What happens if you don't comply? Well, the employer wouldn't necessarily be able to terminate you for cause over this, but they would have to start in putting in progressive discipline. For instance, a verbal warning followed by a written warning, followed by possibly a paid suspension, then an unpaid suspension, and then eventually termination. But generally, unless you can show me how it's unreasonable to be on camera during a meeting, which I'm not questioning you, I'm just personally not seeing what the issue is. Maybe I'm missing something. Then I think you would have to comply with an employer's lawful directions generally. We have another question coming in from YouTube from ANIB 9700. Can you apply for EI while waiting for a decision from LTD? All right. So that's a good question. So generally, for EI, the way I understand it, and that's definitely a question that you can direct to Service Canada directly as well to have the information from the source. But there's two kinds of disability benefits when you have private disability benefits. You have short-term disability and you have long-term disability. Now, you mentioned LTD, which is long-term disability, which in my experience really only kicks in after about 3 months of disability. But you might have been referring to short-term disability. So if you're applying for short-term disability and waiting for a decision, can you apply for EI? I got to say, in that case, I would refer you back to Service Canada. Give them a call. They can let you know if that's possible. It's very likely, though, that if you're accepted for STD, part of your STD will go back to paying back the EI you received for the same period of time. But definitely, that's a question to put to Service Canada. You can give them a call or visit their website and see if they have an answer to that question. Generally, for you to be able to apply for employment insurance disability benefits, you'll need a record of employment that shows that you're off work due to a disability. That's code D on the record of employment. We have a question here from Amanda Pelletier. Can my employer lay me off and then immediately hire someone to fill my position? I live in Alberta. So layoff means two different things, or to different people, right? So a layoff, a lot of people use that in the same sense as a termination, in the sense that they say it's a permanent layoff, I'm never coming back. Or it can be a temporary layoff where you're laid off due to lack of work, and the expectation is you'll be called back once there's a bit more work coming in. So if we look from the position of a permanent layoff, yes, an employer can permanently terminate you and hire someone else to replace you, so long as they provide you with a severance package and so long as the reason for terminating you is not discriminatory. For instance, we hear of a lot of women who are coming back from maternity leave or leaving on maternity leave and are terminated. That's not allowed. You basically require the employer to rehire you after your termination, after your maternity leave, because the reason you were terminated is because you went on mat leave, and that's protected under human rights legislation and employment standards legislation as well. So if there's something like that, a human rights related reason why you were terminated, then no, they're not allowed to do that. Otherwise, they are allowed to do that in Alberta, in the laws of Alberta. Yeah. But I mean, I do emphasize that even though they're allowed to terminate you, doesn't mean they don't have to pay you a severance package. They absolutely do. And then you might be wondering, well, what am I owed in terms of severance? As I was mentioning earlier in the show, it's very easy to find that out. You can visit our website, pocketemploymentlawyer.ca, answer 4 easy questions, and we'll give you an estimate of what your severance entitlements are, so that you can make an informed decision. This is a very important financial decision that people have to make about their future and their finances. Take a second, go find out what you're likely owed. And then if you want, you can feel free to reach out to us. We're happy to talk and delve into your situation a bit more specifically as to why you were laid off and what you might be owed. We have another question here from Philip Eno TV. When can an employer suspend an employee without pay? You're a call center agent. You failed to authenticate a customer before transferring to billing. And you had a similar occurrence in February. So generally, Philip, what I can tell you is that Unpaid suspension is one of the methods of discipline that are available to an employer. So it's really the last stop before a termination for cause. So in my view, that's got to be a pretty serious misconduct. Now, and in my view, that you can't just start there. You can't start. Listen, I'm not going to terminate you for cause, but I'm going to suspend you. I'm not going to. I don't think you can really start there unless it's serious. So you mentioned in February you might have been warned about this failure as well. And in my view, I look at this kind of failure to authenticate a caller before transferring them to another department. That's a failure in performance. It doesn't mean that you were insubordinate. It doesn't mean that you didn't agree that the caller should be authenticated. You might have just messed this one up. All right. So when there's poor performance issues at work, for discipline to be effective, there really has to be some sort of efforts made by the employer to either put you on a performance improvement plan or provide you with more training or coaching opportunities. It's too easy to say, well, you did a bad job here, I'm suspending you. So what do we do about that, Philip? So you have a choice. If you want, you could potentially say, well, this is unacceptable. I work with you. I expect to have hours so that I can get paid. I'm going to treat this as a constructive dismissal. And you could, and be entitled to severance. All right. So you can say, well, this is a completely inappropriate form of discipline. I don't accept that you can lay me off, that you can suspend me without pay. I'm going to require you to pay me my severance now, and I'm leaving. All right. So that's an option you might have. All right. So again, I mentioned it before. You might be wondering, well, what exactly are my severance entitlements? Visit pocketemploymentlawyer.ca. It's a short drop-down menu. You just put in a bit of information about yourself, and then you'll get an estimate of what your severance entitlements might be. So it's pocketemploymentlawyer.ca. So once again, for those of you tuning in, I see the questions are starting to come in rapid fire. I'm Lluc Cerda. I'm a senior associate at the Calgary office of Samfiru, Tumarkin. I'm an employment lawyer. That's all I do. And I'm here to answer your employment law questions today up until the half hour. So if you have any questions, don't wait till the last second. Put them in now so we can make sure to get to them as they come up. We have a follow-up here from Amanda Pelletier. Yes, so Amanda had mentioned to us that she'd been laid off, which I think by which she means terminated, and they hired a replacement for her right away. They did include 2 weeks severance that will be on my last paycheck. I will go to your website. Thank you. You're doing the right thing, because I can tell you with a high degree of certainty that 2 weeks is generally not fair severance. All right. So take a look at our website. You might be entitled to much more than 2 weeks. All right. So yeah, absolutely. And if anything follows from that, you're like, well, I want to get more what I'm owed. Reach out to us, set up a consultation with us, and we'll be happy to discuss your options with you. We have another question coming in here from YouTube. From WC5, I'm in Ontario and have 2,300 plus hours of overtime that hasn't been paid. I also haven't taken vacation since 2018, and I have not been paid out my unused days. So that's a lot of money. You want to get on that, okay? Because that's a lot of money. It should be in your pocket. Now, in terms of overtime pay, overtime is always tricky. You ask your employer, listen, where's my overtime pay? And they're going to tell the first thing they say is, what overtime? I didn't know you were working overtime. Show me proof that you worked the overtime. So WC5, you can imagine to be challenged a little bit on how you kept track of your overtime hours and what proof you have that you worked those overtime hours. If you do have those records, that's fantastic. You can make a request for that to be paid out through the Ministry of Labor. We can help you with the request to the Ministry of Labor, as well as your vacation should also be paid out. And again, you can have the Ministry of Labor order your employer to do that. It's a lot faster than through the courts, so it's a nice little option. If you're not pursuing severance, Ministry of Labor can be a good place to go if you're having disputes about your salary or your hours or your breaks or your holiday pay or your statutory holiday pay or vacation pay, those kinds of things where you're not being paid what you're owed or you're not given the breaks that you need. generally we suggest you go to the Ministry of Labor to have that investigated. We help employees all the time with their Ministry of Labor complaints. They can be a little bit complicated at times, especially overtime pay, because it's, how do we prove that you work those hours? And there's quite a bit of law around when overtime should be paid and when it shouldn't be paid, and we can help you navigate that and make sure that the Ministry of Labor understands your position on the matter. So we have another question here from Jin Park. Jin asks, my company has offices around the globe. If I relocate to work in another country for a 12-18-month term with the same company and get laid off while I'm abroad, how does this impact my severance? Well, that's a great question. So I can't tell you what the laws of the other country will be, but really I think the question you're asking me is which laws will apply. Now, that kind of also depends on which province you are in Canada. So I can tell you in Ontario, it would probably be the law of the other country that would apply. If you're working in the other country, once you've left Canada, it's going to be difficult to argue that you should be governed by Canadian law or Ontario law. In Alberta and BC, it's more likely that you can still make that argument. Either way, that's for like kind of minimal employment standards legislation. In terms of severance, you might not be limited to the minimums under employment standards legislation, and you might be entitled to your full severance, and you're trying to protect that full severance. It is possible in a contract to specify which laws apply. All right. So even if you're working abroad, you and your employer, especially in Alberta and BC, but even in Ontario, can say that the common law of Canada continues to apply to the terms of your employment. All right. So that's something you can put in. And if that's a concern of yours and your employer is wanting to relocate you abroad, then that's a request that you can make. I think an employer would generally be receptive to that in any case, especially if they have if they're a Canadian company, because they know Canadian law, they understand Canadian law and their obligations. They might not fully understand what the law of France or Hong Kong or whatever country might be. So they would feel more comfortable. Everyone's on the same page. We know what the law is that applies to this employment contract, and we're going to spell out what it is. So I have a thank you here from Alicia Bolton. Thanks for tuning in, Alicia. We also have a question here from the host, from YouTube rather, from Milwaukee Motor. All right. Milwaukee Motor asks, can you fire someone without providing proper training? For example, if you don't have education and then a new manager comes in without trying to assist the employee who was trained on old processes. So I think I understand your question, Milwaukee Motor. I noticed you mentioned Milwaukee, so I'll just put out this disclaimer that I can really only answer on what the law is in Alberta, BC, and Ontario. So just in case you're in Milwaukee, this probably wouldn't apply in Milwaukee. But if you are here in Canada, then basically someone can be terminated for really any reason, so long as the reason is not discriminatory. All right. So, but the caveat to that is that person must be provided with fair severance. Okay. I think what you're referring to is, can someone be terminated without cause, for cause rather, where they receive no severance if they haven't been provided with proper training? This goes back to my earlier comment. If there's poor performance issues, which result in you being terminated, basically the employer has a burden of showing that they made efforts to give you the tools you needed to succeed, right? If someone decides to hire me to do heart surgery and I fail completely at that, that's more their fault than mine, because I'm not a heart surgeon, right? So why would I be terminated for cause in that scenario, right? So same thing here. If they institute a new process and don't train you on it, well, it's more their fault than yours that you fail at the job, right? So they can still terminate you so long as they provide you with severance. If they decide to terminate you for cause, I think they've made a mistake. I think we should get a bit more detail about what happened to you and talk to you about how we can get you your proper severance. Again, I've said it a few times in the show, but if you're curious of what your severance might be, Milwaukee Motor, visit our website, pocketemploymentlawyer.ca. We have our severance pay calculator there. and you can just answer 4 easy questions without obligation, figure out what your entitlements might be. And then if you want to reach out to us, we're a click of a button away to set up a consultation with one of our lawyers. We have another question coming in here from Bubba Wilson. So Bubba asks, I work for a company that doesn't pay overtime. We don't do overtime, but other employees do, and they don't get overtime pay. They call it bank time. Is that right? Can they do that? So bank time is a thing. Okay. So basically, imagine you work some overtime. You work, for instance, over 44 hours. So you work a 45th hour in your week. So that 45th hours has to be paid at time and a half. Some employers decide to bank that time. They'll say, we won't pay it to you, but later on when it gets slow or whatever, and we have to cut your hours, or later on if you take some vacation that you don't have vacation time left, you use your bank time to get paid. There's nothing wrong with that. But do remember that it has to be paid at time and a half. A lot of people will bank time at straight time, and that's not legal. Okay, if you're banking overtime pay, it has to be paid at the overtime rate, and basically you should be able to access that either, like I said, through additional vacation or days off, or definitely when you're terminated, that money goes back to you. All right, so you shouldn't lose that money. All right, but otherwise, yes, you can bank. You can bank time, absolutely, to be used at a later date. All right, so we saw quite a few interesting questions here today, and I just want to touch again on poor performance, because it does come up a lot. It's one of the main reasons people get terminated for cause. Okay, poor performance is the hardest, in my view. It's the hardest for cause reason that an employer can choose, because it's the hardest to prove. All right. If you're a poor performer, then the employer has an obligation to try to make you a better performer before they show you the door. Okay, so they can always terminate you, as I mentioned earlier. They can always terminate you so long as they provide you with a severance package. They have no obligation to continue to train you or to make you better at your job. They can terminate you, replace you with someone that has the skills they need. That's totally allowed, but they have to pay you your severance package. But a lot of employers don't do that. Instead, they'll say, well, listen, you're terrible at this. Here's the door, no severance for you. Big mistake a lot of employers make, because poor performance is the hardest area of just cause to prove. So if you're having issues with your employer, that they're claiming you're not performing well, that you've been terminated because you weren't performing well, that's definitely one that you want to get in touch with us. We'd be happy to discuss that with you, whether the employer is legally allowed to terminate you without severance. We have a question from JX2 here. In terms of severance, can the employment law minimum supersedes the minimum in a labor law contract in the event the amount works out to be less than the minimum that's set out by the province for employment law? So JX2 makes a good point. There are certain minimums amount of severance that everyone is owed, and that's spelled out in employment legislation. All right. So, for instance, in Alberta, we have the Employment Standards Code. It sets out minimums amount of severance that you're owed. The kind of maximum minimum severance that you could be owed is 8 weeks. All right. So, if you've been somewhere 10 years in Alberta, you get terminated, you might be entitled to a maximum of 8 weeks under the Employment Standards Code. That's not what we refer to when we're talking about your full severance. When you go visit our pocket employment lawyer, severance pay calculator, we're not talking to you about the minimum you're owed under the Alberta law. We're talking to you about what a judge could potentially award you in court. A judge will generally not provide you with the absolute minimum that you're entitled to. They will provide you with what they think is reasonable. And that's where we get the numbers that we have on our pocket employment lawyer calculator. All right. Now, that said, a lot of employers now, what they do is they hire you, they present you with an employment contract that says, well, if we terminate you, this is how much severance you're getting. And often what they'll say is that the maximum you can get is the minimum under the Employment Standards Code. Okay. So like I said, again, a maximum of 8 weeks. It's a very frequent clause to see in employment contracts nowadays. And what I can tell you is 90% of those clauses are illegal. All right, 90% of those clauses are not compliant with the law, and there's a lot of cases where basically they will just be thrown out. All right, they won't have any effect if they're not compliant with the law. In which case, you're going after your reasonable full severance. All right. So if you have a contract that says, well, if you're terminated, you're only entitled to certain amounts of minimum pay, contact us. We need to review that clause, make sure whether it's enforceable or not. And if it's not enforceable, you might be entitled to a lot more than what the contract or the termination says you are entitled to. So definitely, that's a good time to have an experienced employment lawyer, such as the team here at Samfiru, Tumarkin, review your contract. Let us know, let you know what your entitlements might be. I have two more questions to finish off the day here. I have a question from Ashley Burrows. My husband works in construction with a company in Alberta. Due to minor, lost you. But is usually doing work out of a location in BC. Which province would be considered to be employed legally? So that's in between Alberta and BC, it's a relatively complicated question. In Ontario, it's very easy to figure out. In Alberta and BC, it really depends on where are the parties located. Does your husband live in Alberta or does he live in BC? The company you said is based in Alberta. Where was the employment contract formed when they come to a deal here in Alberta? Where is the majority of the work being done? All these things get factored in to figuring out what law applies. But all that to say, that law that applies really only speaks to which employment standards legislation we refer to. If we're looking at your full severance, then the law between BC and Alberta is pretty much the same. So it doesn't have an impact there. But if you're looking at, well, which statutory holidays do I get off? What is the overtime threshold or stuff like that? Then we have to look at the employment standard legislation of each province. And then we're going to have to look at those kind of contextual factors to see which law provides the most. My reading from what you're telling me, if the contract was formed as the agreement to work together was formed in Alberta, if both the company and your husband live in Alberta, those are two strong indications that this is probably going to be governed by the law of Alberta, even though a lot of the work is being done in BC. And we have one last question here from Union Accountability Channel. Can an employer unilaterally make a new policy while under a current CBA, from which I understand is a collective bargaining agreement, altering the terms of employment, changing the hours, wages, and working conditions? Union or non-union? Thank you. Well, CBA really refers to union. So if you're talking about collective bargaining agreement, that's a unionized question. Unfortunately, you'd have to speak to your union representative about whether the employer is allowed to do that. In the non-unionized context, we often do have policies that come in, during the course of an employment contract. It could be things related to overtime policy. In Ontario, every employer now is required to have a electronic monitoring policy. Things like that really come up a lot, and they happen. It doesn't create a new employment contract. It's just added on to the policies in the company. But I'm always, the point I try to make is that sometimes employers try to sneak in a new employment contract by the form of a policy. If a policy says, well, now everyone that's full-time is now going to be part-time, that's a new employment contract. You don't have to accept that. You can say, I'm not accepting that. I'm going after my severance. If a policy says, well, the new rate of pay is 50% less than what it used to be, that's a new employment contract. You don't have to accept that. You can say, I'm not accepting this change. You owe me what we agreed to was my pay. If you don't want to pay me that, then terminate me and provide me with my severance because I'm not working for 50% less. And then working conditions depend what the working conditions are. If the employer creates a policy saying, well, we're moving locations to out of province, you either pick up and move with us or we're going to think that you quit and put that in a policy. The fact it's in a policy doesn't protect them from the consequences of that, which is basically if you can't afford to move out of province to stay with the company has terminated you and owes you severance. So putting it in a policy is not a magic bullet that really prevents you from saying you've been constructively dismissed. No, you've been constructively dismissed if the change to your employment conditions is serious enough. To know whether it's serious enough or not, reach out to us. We're at employmentlawyers.ca. We're happy to answer any follow-up questions you might have. Employmentlawyers.ca is a good way of reaching out to us. If you're looking for the severance pay calculator, it's at pocketemploymentlawyer.ca. And once again, my name is Lluc Cerda. I'm a senior associate here at the Calgary office of Samfiru Tumarkin. We work in employment law. We work in employment law across the country in BC, Alberta, and Ontario. And if I haven't gotten around to your question today, don't despair. We're doing another one of these shows tomorrow at 12 p.m. Pacific time. My colleague Madalena will be here to answer all your questions, and we look forward to seeing you then. Thanks for tuning in today. It's been great to answer all your questions, and I hope you have a nice rest of the day. Bye now.